Hey there. Welcome to All Things Social Security. I'm Stephanie Joy. Whether you are a first-time viewer, an occasional viewer, a subscriber, or one of the three tiered benefactor members, I want to welcome you and let your video begin. Remember, if you haven't checked out the memberships, it might be something up your alley because it gives you an opportunity for a little more Social Security disability attorney attention if you need it, but don't have representation and don't want to do a full-fledged consultation. Okay, have a great one, guys. Stay tuned. Good morning. We have another court ruling. This is in the 10th Circuit. So let's hop to it. This is Green versus the commissioner. Okay, and this is from November, guys. And what I'm a little belated in getting these out, but it has to do with veterans. And it came out during the month of Veterans Day. So I am just very late in getting it out, but anywho, I apologize. All right, so it's a 10th Circuit case. And apparently, by the way, when I say it came out uh, available to me by my go-to who does summaries of these items, but I think this is a 2018 case. But let's listen to it because it's about our veterans, and it's a good one. Okay, and it was handled actually by I recognize Lisa McNair Palmer. Um, I don't think I know who Tim White is, but apparently they worked together and they handled this case that created this wonderful precedent. So let's hop to it. It is the 10th Circuit, but as I've said before, a circuit case in one circuit can really be very useful to cases in other circuits, in my opinion. I have cases in all circuits, so to me, it's important. Okay, so here we have an Army veteran who was denied, and I'm getting this from Adriana. Thank you, Adriana. You're the best. The Army veteran was denied SSD. And we can talk separately about, I know a lot of people get upset, a lot of veterans when they get denied by SSD when they're 100% P&T, they get really perturbed. And I understand where they're coming from, although I understand why one does not equate with the other. But we won't go into that here. Um, in this case, he was 100% unemployable by the VA because of his PTSD and other service-related conditions. So he was 100% unemployable, which is a little different. Despite this, the ALJ concluded that Green could perform medium work. And just as a little interruption, when I talk about medium work, it could be sedentary, light, medium, heavy, very heavy. Okay. And here they found he could do medium work, which is higher than light. Light is limited at 20, and medium would be above that. When I say 20, 20 pounds. I know I'm rushing here, right? Um, so he dismissed the ALJ dismissed the VA's findings and focused instead on Social Security's stricter criteria. Okay. And I will agree it's stricter. You know, the difference is where it's not stricter is that it does not have to be service connected, right? Whereas the VA it does. But in terms of the level of severity, that is where I think the SSA rules are far stricter. I do have a video, I think, on the comparison of the two, and I'll try to attach that. Okay, so the main issue on this appeal was the ALJ's alleged failure to properly consider the VA's unemployability rating. The court emphasized that while VA decisions are not binding on Social Security claims, they should still be properly analyzed. Very good. The ALJ, however, discounted the VA's assessment by merely stating that the two agencies have different standards. We all knew that without addressing the substantial psychological evidence that the VA relied on. Okay, so it sounds like the ALJ just kind of, I see you're 100% unemployable, but there are different standards, therefore I'm not going to give it much, attention, that unemployability rate. Sounds like that's what happened here. And the circuit court, I suspect, is going to say, no, no, no. You still have to look at all the material that got the VA to that result, because that could very well implicate the severity of an SSD finding, right? Okay. The 10th Circuit did in fact reverse the ALJ's decision, citing the failure to adequately consider the VA's disability rating and the related mental health evidence. The Circuit Court remanded the case. They didn't reverse it and give him benefits, claimant Green, but remanded it back to the VA. I'm sorry, back to the ALJ for another hearing. That's basically what they do. And I think as a pathway, what happens is they remand it back to the SSA, which brings it to probably the appeals council. Appeals council decides whether they're going to do anything differently than they did before, because remember, it had to come from the ALJ to the appeals council, get another denial, and go to the federal district court and then up to the circuit court. So it goes back to the appeals council, who could now make a different thing and remand it themselves, um, or award it, which is not that typical. So usually it's a remand back to the ALJ for another hearing. So the case is remanded, reinforcing the idea that the ALJs must provide more than a cursory dismissal of the VA's findings, especially when the claimant's mental health issues, such as PTSD, are significantly involved. Here are some key takeaways from the case that Adriana shares with us. Cross-agency decisions. While the VA and Social Security disability criteria differ, ALJs must engage with the underlying evidence and not just dismiss the rating. Mental health evidence. This case highlights the importance of thoroughly addressing psychiatric evaluations, especially when PTSD or other mental health issues are central to the claim. So it was central to the VA claim, but apparently it's also central to the Social Security disability claim. So that would be important. And then the last one she talks about is proper consideration. Ensure that when cross-referencing other agency findings, like the VA, the ALJ discusses specific evidence supporting or contradicting the findings instead of broadly dismissing them. So the ALJ, it sounds like, should have gone through each and every item, and this goes without saying, really, that the VA used to find the person unemployable, and really analyze them specifically towards, what kind of limitations stem from them in terms of the work tasks that the ALJ is tasked with, determining what the residual functioning is, left over. What kind of residual functional capacity does that person with those severe limitations, and surely he found them severe, what do they specifically deprive the person's capacity of? Because that's going to determine whether or not there are any jobs he can do. And that's assuming he doesn't meet a listing, but they have to look at that stuff too, when they're looking at the listing, right? Step 3. Okay, that's it, guys. That would be Green versus the SSA. I'll talk to you later. Bye. And thank you to all of our veterans.